This nomination comes before us at a time when we are witnessing seismic shifts in our democracy. Foundational elements of our government, including the rule of law, have been challenged and undermined. Today, our democracy faces threats that we never would have believed would be occurring not that long ago. Our intelligence agencies agree that a foreign adversary attempted to interfere in our most recent election, and it's happening again. In the words of the President's Director of National Intelligence, the lights are blinking red. There is an extensive ongoing investigation by a special counsel. The President's private lawyer and campaign chairman have been found guilty of multiple federal crimes. The man appointed as special counsel in this investigation, a man who has served with distinction under presidents from both parties, has been under siege. The dedicated public servants who work in our Justice Department, including the Attorney General and the FBI, have been subjected to repeated threats and have had their work politicized and their motives questioned. In fact, just this past weekend, federal law enforcement was called out, was rebuked by the President of the United States for simply doing their jobs, for prosecuting 2 white-collar defendants, one for insider trading, one for campaign theft. Why? Because the defendants were personal friends and campaign supporters of the President of the United States. As a former prosecutor, as someone who has seen federal law enforcement do their jobs, this is abhorrent to me. So no, this is not normal. And the last branch, the third branch of government, our courts and individual judges, have been under assault, not just by a solitary, disappointed litigant, but by the President of the United States. Our democracy is on trial. And for the pillars of our democracy and our Constitution to weather this storm, our nation's highest court must serve as a ballast in these turbulent times. Our very institutions and those nominated to protect these institutions must be fair, impartial, and unwavering in their commitment to truth and justice. So today we will begin a hearing in which it is our duty to carry on the American constitutional tradition that John Adams stood up for many centuries ago. And that is to be, in his words, a government of laws and not men. To me, that means figuring out what your views are, Judge, on whether a president is above the law. It is a simple concept we learned in grade school, that no one is above the law. So I think it's a good place to start. There were many highly credentialed nominees like yourself that could have been sitting before us today. But to my colleagues, what concerns me is that during this critical juncture in history, the President has handpicked a nominee to the court with the most expansive view of presidential power possible, a nominee who has actually written that the President, on his own, can declare laws unconstitutional. Of course, we are very pleased when a judge submits an article to the University of Minnesota Law Review, and even more so when that article receives so much national attention. But the article you wrote that I'm referring to, Judge, raises many troubling questions. Should a sitting president really never be subject to an investigation? Should a sitting president never be questioned by a special counsel? Should a president really be given total authority to remove a special counsel? In addition to the article, there are other pieces of this puzzle which demonstrate that the nominee before us has an incredibly broad view of the President's executive power. Judge Kavanaugh, you wrote, for example, in 7 Sky v. Holder, that a president can disregard a law passed by Congress if he deems it to be unconstitutional, even if a court has upheld it. What would that mean when it comes to laws protecting the special counsel? What would that mean when it comes to women's health care,